Hi, my name is Jordan Korfman, and this is my critical assignment on ethics in criminal justice. I chose to do my presentation on ethics in law and in the court system, and specifically looking at lawyers and how they interact with their clients and when ethics come into play regarding that. I wanted to start out my presentation by saying how ethics is a huge factor that comes into play in all aspects of life, but something that I think shines exceedingly bright in the field of criminal justice. Ethical values within criminal justice are very important due to the fact that they set moral standards for individuals working within this field. Ethical values and moral standards allow for professionals to make fair decisions, which helps create justice and establish trust within public service systems. One area of criminal justice that has a strong need for ethical values that I found was in the court systems, specifically within looking at lawyers and lawyer-client relationships. When dealing with criminals, the lawyer needs to set boundaries with their client and be able to determine when to make ethical choices to protect themselves, society, and, depending on the case, their client. Ethics and the understanding of them must come into play in these relationships, especially when dealing with issues of client crime, confidentiality, and personal life of these lawyers as well. I wanted to start off by kind of explaining what a lawyer-client relationship is. In issues regarding legal criminal justice cases, the client is really heavily reliant upon their lawyer for advice and support. The relationship between the lawyer and the client is supposed to be equal, and this involves a lot of trust and mutual respect in order to work. Cindy Banks stated that incompetence or wrongdoing on the lawyer's part is considered betrayal of the client's trust. The lawyer's job is to hear the client's side of the story and then build off of that. Without trust, the lawyer-client relationship does not work. However, ethical issues do come into play sometimes when determining how the lawyer is to proceed with the cases and determine if they're going to take the clients on as their own or if they're going to have to withdraw from the client and things like that. Although the lawyer-client relationship is very important and does establish a lot of trust and respect for each other and a big part of the court system, there are certain aspects where the lawyer-client relationship does need to end. In the United States, lawyers do have the right to withdraw their presence from a lawyer-client relationship. According to the American Bar Association, lawyers can remove themselves from representing a client if the client insists upon pursuing an objective that the lawyer considers repugnant or imprudent. Ethics plays a large role in cases where lawyers find themselves needing to withdraw from the client. The rules of professional conduct of the State Bar of California grants lawyers permission to withdraw under 3 circumstances. The first circumstance is if the attorney knows or should know that the client is bringing an action, conducting a defense, asserting a position in litigation, or taking an appeal without probable cause for the purpose of harassing or maliciously injuring another. The second reason why a lawyer may be able to withdraw from their client is where continued employment would result in the violation of the rules of professional conduct or the State Bar Act. And the third reason is where an attorney's mental or physical condition renders effective representation unreasonably difficult. In these relationships, ethics plays a very large role, especially when understanding different limitations and rights that go into effect in the lawyer-client relationships. Lawyers must make ethical decisions when hearing the client's cases and determine if they are able to take the case on to defend them or if they will have to pass on it. When a client seeks to pursue in criminal conduct or has the intentions for the lawyer to act under criminal conduct as well, it is the lawyer's ethical duty to make this known and withdraw from the case. One aspect of these lawyer-client relationships that is very important, especially when looking at ethical issues, is the issue of confidentiality. Within the U.S., confidentiality is a right of the client, not to the lawyer. Lawyers can take these cases and agree to do what's best for the client, not what's best benefits themselves. Confidentiality and keeping the client's personal details private is a huge ethical issue that also creates the relationship of trust between the client and the lawyer. When looking at confidentiality within lawyer-client relationships, there's usually 2 sides or 2 different opinions. The first side is the lawyer-client confidentiality. This is where the lawyer works as an advisor in many of these cases and needs to be aware of all of the details in order to best advise their client, as this also comes into play when building that trust of the relationship. The lawyer is to represent the best interest of the client and therefore needs to know the details of the case. When looking at the opposite end, other people have different opinions, where thinking it's the lawyer's ethical duty to declare if the client is guilty. Some argue that lawyers have the ethical duty to testify against their clients as well if they do admit to guilt to them. However, confidentiality differs from the lawyer-client privilege, and none of the information provided is to legally be used as evidence against their client, and therefore the lawyer is not legally obligated to do so. Another aspect of a lawyer-client relationship that deals with ethical issues is the topic of client crime. The rules and regulations regarding lawyer-client confidentiality have their exceptions, and this is one of them. A main exception to confidentiality agreements come into play when dealing with client crime. If a client is to confide in their lawyer expressing interests of furthering a crime, the lawyer is ethically called to negate confidentiality and disclose this information to whoever is needed to disclose it to. In client crime, a general ethical rule is that if a lawyer is able to prevent future crimes from occurring, it is their ethical duty to do so and to share what their client had told them about these crimes. One thing that I saw as a really good example when looking at what a lawyer is to do ethically in dealing with issues with client crime was an example of the buried bodies case. In this case, the client told his lawyer of 2 other murders that he committed, where the bodies were, and how to find them. The 2 other crimes had already happened, and the lawyers chose not to disclose this information with any other individual, and instead used it to form a plea bargain for their client. In this example, the lawyers did act properly under the ABA Code of Ethics. This is due to the fact that the crimes had already happened and the individuals were already killed. However, if the victims were still alive and the attorney found out about this information, it is their ethical duty to report it and to prevent further crime from happening or harm being done to these individuals. This example presents moral and ethical issues, considering the lawyers knew about the bodies and used their discretion about them, when peace could have been brought to the missing people's families. This presents the idea that ethics is always present within the criminal justice field, and these lawyers often have to determine what is the best course of action morally, ethically, and lawfully. Ethics also is an issue that is heavily present within lawyers' personal lives. Though they are ethically called to act in the best interest of their clients, they are not to act in ways that violate their integrity or violate ethical principles. Lawyers are called to act ethically, especially considering the gray areas that they have to be put in these cases, and just like the buried bodies case, determine what is the best course of action. Lawyers must make ethical decisions regarding their cases, considering many cases involving convicted criminals highlight the need to separate personal opinion from the professional responsibilities. Personally, I think that faith contributes a lot when looking at things with ethical issues, especially within the criminal justice system and in any field of work. For an example, if I were to be put into the shoes of an attorney, I personally would find it to be really difficult to have the knowledge of murders and where missing bodies are and not be able to tell the families. I think this is due to an empathetic standpoint, and a standpoint that comes kind of from faith and like a moral obligation to bring justice. However, on the opposing end, I can also see how faith can contribute to these things where the lawyers do have to determine the best course of action, and also we are called to love and to care for other people, and they do really help support a lot of the people that a lot of regular people would kind of shun, like these criminals, and I do think that that also contributes a big part when it comes to faith. To conclude, I think that ethics and moral values play a huge part in everyday life. However, they can also become heavily prevalent within a workplace environment as well. Within the world of criminal justice, ethics is exceedingly important when it comes to making fair decisions, bringing justice, and establishing a level of trust within the public service of criminal justice. In law and working as a lawyer, ethical situations become present very often. And in these cases, the lawyer must be able to have an understanding of ethical choices and be able to determine what is best for their client, for society, and in some cases, themselves. That is the end of my presentation. Thank you so much for listening.